5 seconds to go. Start. The ESIC Recruitment Regulations 2008 were issued by the ESIC in the exercise of its powers under Section 97(1) and Section 17(3) of the ESI Act. These regulations introduced the cadre of specialist teaching in the ESIC and governed all appointments to the teaching faculty posts in ESIC medical colleges. The ESIC Recruitment Regulations 2008 embodied a requirement of 4-year service as assistant professor for promotion as an associate professor. The ESIC Recruitment Regulations 2015, which were made on 5th July 2015, stipulated a requirement of 5-year service as assistant professor for promotion to the post of associate professor. The preamble of the ESIC Recruitment Regulations 2015 notes that these regulations were to supersede the ESIC Recruitment Regulations 2008 and were made with the approval of the central government. Accordingly, the ESIC Recruitment Regulations 2008 and ESIC Recruitment Regulations 2015 have statutory effect by virtue of Section 97(3) of the ESI Act. It is settled law that regulations framed by statutory authorities have the force of enacted law. A constitution bench considered the regulations framed by several statutory authorities considered as state within the terms of Article 12. Chief Justice held that the regulations have the same effect of law and bind the statutory authorities. The characteristic of law is the manner and procedure adopted in many forms of subordinate legislation. The authority making rules and regulation must specify the source of the rule and regulation making authority. To illustrate, rules are always framed in exercise of the specific power conferred by the statute to make rules. Similarly, regulations are framed in exercise of specific power conferred by the statute to make regulations. The essence of law is that it is made by the lawmakers in exercise of specific authority. The virus of law is capable of being challenged if the power is absent or has been exceeded by the authority making rules or regulations. On the dates when the contesting respondents joined the service of the appellant 7th February 2014 till 26th June 2016, their promotions were governed by the ESIC Recruitment Regulations 2008, which came into effect on 2nd May 2009 and mandated 4 years of qualifying service for promotion from assistant professor to associate professor. When the contesting respondents had completed 2 years of service, they were governed by the ESIC Recruitment Regulations 2015, which came into effect on 5th July 2015 and mandated 5 years of qualifying service for promotion from assistant professor to associate professor. Thus, the DACP scheme facilitating promotion on the completion of 2 years of service is not applicable to the contesting respondents when the regulations have a statutory effect that overrides the office memorandum dated 29th October 2008, which implemented the DACP scheme. The advertisements issued by the appellant mentioned that the DACP scheme would be applicable for its recruits. However, it is a settled principle of service jurisprudence that in the event of a conflict between a statement in an advertisement and service regulations, the latter shall prevail. In UP Public Service Commission, a two-judge bench of this court clarified that an erroneous advertisement would not create a right in favor of applicants who act on such representation. The court considered the eligibility criteria for the post of Civil Judge Junior Division under the UP Judicial Service Rules 2001 against an erroneous advertisement issued by the UP Public Service Commission and held the present controversy has arisen as the advertisement issued by PSC stated that the candidates who were within the age on 1st July 2001 and 1st July 2002 shall be treated within age for the examination. Undoubtedly, the excluded candidates were of eligible age as per the advertisement, but the recruitment to the service can only be made in accordance with the rules, and the error, if any, in the advertisement cannot override the rules and create a right in favor of a candidate if otherwise not eligible according to the rules. The relaxation of age can be granted only if permissible under the rules and not on the basis of the advertisement. If the interpretation of the rules by PSC when it issued the advertisement was erroneous, no right can accrue on basis thereof. Therefore, the answer to the question would turn upon the interpretation of the rules. Stop.